So let's talk about some common estate planning techniques that are happening. And when you think about it, where does most estate planning happen today? Because every day people engage in estate planning without even realizing it. You go to the bank officer says, why don't you add one of your kids to this account, just in case something happens? You go to the HR department. Well, you probably want to name your spouse as your beneficiary, right? On your benefits that you have at work. The bank teller was trying to address the living, probate, and disability issues. The HR department is addressing the give what I have, to whom I want, when I want part of planning. So what are some common estate planning techniques that are being used today? And I've identified 6 estate planning techniques. So let's look at some of those. First, the most common one, do nothing. It's very common. Studies show that over 50% of us have no formal estate plan in place today. However, doing nothing doesn't mean you don't have an estate plan. Because never fear, because the government has provided for you. It's called intestacy. And first, got the living probate. That's where someone's disabled. The probate judge determines who's going to make your decisions. It's going to determine who's going to make your healthcare decisions, what those desires are, and tell you where you're going to live. And then the judge will appoint someone to manage your assets, pay your bills, determine what you can have. And the state legislature set the rules for the probate judge to determine your disability needs. Then the state has provided for your wishes on the last part of the estate planning definition. Give what you have, to whom you want, when you want, and how you want. And that's the intestacy plan. The state legislature created the plan for phase 3, and they have determined who gets my stuff for you. I haven't met anyone yet who thinks that there is any member of the state legislature who can determine their disability or asset transfer needs better than they can for themselves. Doing nothing means at death, there is probate, and your assets simply distribute according to the state plan rather than your plan. During disability, there's a probate. The probate court is in control of your decisions and your assets. Second common planning technique, probate avoidance planning, typically done through joint ownership. Usually thought of as joint ownership with rights to survivorship, but it can be simply joint tenants. And many try to use this technique on their own, or what I call do-it-yourself planning, but they misuse these 2 types of ownership, and the legal result of the 2 is quite different. Usually the do-it-yourself person ends up creating more work for an attorney later to clear up the mess left behind when trying to create this plan without understanding the differences that the language makes. And that, of course, misses the last part of our definition, reducing costs and expenses. When it comes to estate planning, that's all part of what we're trying to do. So let's look at the way most people think of it as joint with rights to survivorship. And what does joint with rights to survivorship mean? With joint rights to survivorship, you're adding someone to your assets as an owner with you. They've got full rights to the assets at that point because they are an owner. And at death, the surviving owner has full ownership, whether they deposited any funds in that account or whether they paid anything toward maintenance of the real estate. Assets titled joint rights survivorship now are exposed to another person's creditors too. So let me explain that with a story. Elderly woman came into the office one day and said, "The bank took my money." I asked her, "Can you explain what you mean by that?" And she went on to say that she wanted to withdraw some funds and that her account was at 0. So together we called the bank branch manager, and the manager explained they got served with a writ of garnishment. And so they had to satisfy that judgment and delivered the assets as the garnishment notice instructed. So I asked my client, "Were you sued?" And she said, "No." The manager explained it wasn't a judgment against her, it was a judgment against her son. And unfortunately for her, the son hadn't put any funds in her account, but she had put him on the account as joint owner just in case she got disabled and needed him to help. She lost control of her asset as a result because the plaintiff's attorney did a search, found her son's name attached to the account, went after the funds to satisfy the judgment against the or an account owner. So she lost her life savings as a result of exposing her assets to somebody else's creditors. Joint ownership really only postpones probate, by the way. Eventually, there is an owner and a potential for unintentional disinheritance, because once there's only one owner, it's their asset to do with whatever they want. In disability of either owner, the court's in control, and it can be very difficult to remove the co-owner who is placed on title just in case. Your assets are exposed to the lawsuits and creditors of the other owner. You may cause unnecessary taxes by that gift, by the way, losing the step up in capital gain, and that can take quite a bite out of what you've left for your beneficiaries. The ownership is set up as just joint tenants, no right of survivorship. Then there's no transfer at death to the surviving owner. The co-owners each own one part of the asset. And in disability, the court again is in control of that share. In the death, the share owned by the now deceased co-owner has to go through probate because it's in their own name. Joint without survivorship is like a betting game. You're betting that people are going to die in the correct order to transfer the asset as you want. Sometimes people don't cooperate and they die out of order. So let me explain again with another story of something I handled in my practice. Mom came in to see me because her son-in-law did a probate avoidance plan, carefully splitting all of her assets, joint right survivorship with her two daughters. Every month she sat down and she wrote 2 checks to the utilities, for example, so she could keep the shares equal. She had 2 checking accounts and half went out of each account. Unfortunately, daughter number 2 didn't cooperate. She died out of order. And so she wanted to know, well, what's going to happen? She had no will because her son-in-law told her there wasn't any need because everything passed outside of probate. By dying in the wrong order, now Mom owned those assets in her sole name because she was a surviving joint owner. If we had to probate those assets because Mom died, daughter 1 would get at least half of those assets, and the children of daughter 2 would get the other half. She accidentally disinherited her grandchildren, who she wanted to have take their mom's share. So we can have unintentional disinheritance. We expose our assets to somebody else's creditors with joint rights survivorship.